Hi, everyone, and welcome to this video where I demonstrate and explain how to fill out OREC's listing agreement exclusive right to sell. My name is Brad Anderson. I am the broker and owner of White Rock Realty, and we operate in the states of Texas, Oklahoma, and New Mexico. And if you are not a White Rock Realty agent, you could be if you want to go to this website right here, and you can find out all about us, what our commission structure is, what we have to offer, and see if it might be a good fit for you. So this is part of a video series where I review contracts in Oklahoma, and I put together a real quick cheat sheet where I list out all the forms and documents that you'll need for a listing transaction, a buyer transaction, and a lease transaction. If you want this, I am more than happy to give it to you. You can either text me, email me, call me, whatever you'd like to do. All right. So I put education at the center of everything that we do at White Rock Realty. So it's important that whether you're an agent here or not, that you are informed. So take me up on that. So without further ado, let's launch into how to fill out the listing agreement. Okay, so the first order of business is to fill out the property address. So that would be the street number, street name, city, state, zip code. Legal description is something different. So that might be a lot and block situation. It is literally anything that is in the central appraisal district of the county in which this house is in. Okay, it's important to put that in there. What usually trips people up sometimes is when the seller has two separate parcels of land right next to each other that they want to sell together. And it has two separate parcel IDs or legal descriptions. It's important to put both of them in here. All right. And then it goes on to say, together with all fixtures and improvements and all appurtenances, subject to existing zoning ordinances, so on and so forth, for the price of. All right, so you're going to put in the price. Let's say it's $400,000. And by appointing broker as exclusive broker, seller agrees to work through the broker for the sale, option, or exchange of the property and to refer to broker all inquiries received in any form from other real estate brokers. So in other words, nobody can go directly to the seller. Okay. This agreement begins on and terminates at midnight on this date. So I would put in there at least 6 months. All right, so in this case, that'd be roughly that date. Okay, it's going to take a 30-day close. It's going to take 30 days for a buyer to find you. You just want to make sure that it's not too abbreviated. All right, and then really the main reason why we have a listing agreement is to memorialize how we as the listing broker are going to get paid. And that is in paragraph 3. As I said before, when OREC bolds or underlines anything, it's important. So it says, seller acknowledges the compensation in this agreement is fully negotiable and not set by law. That this is a direct result of the NAR settlement. The compensation section in this agreement must be completed before it can be signed by the seller. This agreement is not enforceable if this section is left blank. So let's see what the options are. Seller agrees to pay compensation equal to the greater of X%. Now it's going to be 0 if you leave it blank, of the total sales price of the property plus, and you have the ability to put an additional amount. Okay, so maybe it's, 6% plus an extra $1,200 because they want to compensate you for marketing, right? Or you can get rid of that. And let's say you just agree to list that home for a flat fee of $5,000. All right, so here's where it gets tricky. I want you to pay attention. This is the paragraph 3A in which you put the total amount that they're going to compensate you for if you are splitting the commission with the buyer agent. So that's kind of the way it's always worked in the past. So let's say that we agree to a 6% commission. All right. Then it comes down and says, paragraph 3B, seller acknowledges that seller is not required to make any offer of compensation to a buyer's agent. In the event a cooperative agreement or supplement to split compensation with another licensed realtor occurs, the compensation provided for in section 3A, right here, shall be split this way. So let's say that you agree to pay 3% of the total sales price of the property, or again, you can put a dollar amount in there, to be paid to the seller's broker, and X% to be paid to the buyer's broker. Okay, so it's 3 and 3. So it's very important that this reflect the total amount. Now, it then gives you the opportunity. Seller does or does not authorize the broker, meaning the listing broker, to disclose the amount of compensation to be offered to the buyer's broker in marketing and advertising the property. So it's a yes or no. So what does this look like? Well, because the compensation is no longer in the MLS, the buyer's agent is going to ask you, is the seller going to contribute to the buyer's agent's commission? And this is where the seller authorizes you to either tell them, yes, I am, or I'm not going to tell you. All right. So what if it's, I don't authorize? Well, how's that going to look? Well, the buyer's agent is going to have to send forth their offer inclusive of what they want in commission from the seller. And the seller at that point decides if they're going to pay it. So the buyer's agent's taking a big risk, right? So best practice is the seller should authorize you as the listing agent to communicate to the other agents that come forward with a buyer what that compensation might be. If they don't, it's just going to slow things down and complicate things. Okay, that's just my personal opinion. You don't have to do it that way, but that's what it might look like in practice. Okay, the compensation shall be due and payable upon the occurrence of any of the following: the sale or exchange of the property during the term of the agreement, whether procured by the broker, seller, or a third person. All right, so if the seller decides to sell it to their neighbor, they still owe you. All right, CII, the sale or exchange of the property within X days after the termination of the agreement, if with anyone to whom the broker has showed the property or with whom the broker has negotiated concerning the property prior to termination of the agreement. So what this means is, if the agreement was through July 16th and on July 18th, the contract is no longer in force, maybe the home's even off the market because they didn't relist with somebody, but someone comes forward with a buyer who's seen the property within that time frame and they want to buy it and the seller agrees to sell it to them. This would determine how many days you're going to allow for that. So let's say it's, 14 days, 2 weeks. All right. So again, if anybody comes forward that's looked at it before, then the seller still owes you a commission. All right. Next, if broker procures a buyer who is ready, willing, and able to purchase the property at the price and on the terms set forth herein, or at property price and terms as shall be acceptable to the seller. compensation shall be due and payable. The sale or exchange of the property during or after the term of this agreement to any party to whom the property is rented or leased during the term of this agreement or within X amount of days after. All right, so if there's a renter in there and they want to buy it, you still get paid. Okay, so paragraph 4 are all the things that the seller is agreeing to if a contract is actually executed. And they are all the common sense things that you would think that the seller would be agreeing to. They can legally convey the property. There's no liens or encumbrances. They'll furnish a clean title, all those different things. All right. And then in paragraph 5, it pretty much says, in accordance with Oklahoma Residential Property Condition Disclosure Act, the seller is obligated to produce either the residential property disclosure statement or a disclaimer statement. In other words, if they've not lived in the property before, they can issue a disclaimer statement, but they are not exempt from one of these two things. Broker shall provide a copy of the seller's disclosure statement or disclaimer statement, whichever is applicable, to potential buyers or the broker. So everybody gets one. Broker shall disclose to a potential purchaser any defects in the property actually known to the broker, which are not necessarily in that disclosure. All right. So if something pops up later and the listing agent knows about it, they are obligated to tell any buyer coming forth. And then paragraph 6 talks about accessories, equipment, and systems. The following items, if existing on the property, unless otherwise excluded, shall remain with the property at no additional cost to the buyer. So as time has gone on, this list gets longer and longer, but these are the things that stay with the property. Okay. Some of these things can be pretty interesting. And then additional inclusions. The following items shall also remain with the property at no additional cost to the buyer. So it's not uncommon for refrigerator and washer and dryer to go with the seller onto their new residence. Buyer walks in and says, hey, I like that Sub-Zero stainless steel refrigerator. I want that. And I want those front load LG washer dryer that I see in that laundry room. What do I need to do to get that? Well, if the seller is willing to include that, then the seller includes that here. Okay. Now that eventually becomes part of the contract. But if when listing the home, the seller has made a conscious decision to any buyer, hey, I'm willing to part with these extra items that deviate from this, they go here. All right. Now, similarly, if you want to exclude any items, you would put those here as the seller. So what might those be? Ring doorbell. I'm taking that with me. A family heirloom chandelier in the foyer. I'm taking that with me. The mounted TVs and their brackets in the game room. I'm taking those. Now, mind you, in the Ring doorbell example and in the TV example, you can't just take those and not repair the damage that was caused by those. If it was a Ring doorbell, you go ahead and take it, but you're going to have to replace it with a regular doorbell. If you take the wall mounts off from a TV, you got to patch the holes. Okay. All right. So then it goes on to talk about lead-based paint. So this confuses a lot of agents. If the home was built before 1978, this applies. Any home built before 78, there's a chance that there was lead-based paint used in that home. What if the home was built in 1978? Doesn't apply. It only says before. So if the build date on a home is 1978 or later, it doesn't apply. But it does say that if it were built before 1978, the seller needs to complete a disclosure and acknowledgement of lead-based paint. And the broker, listing broker, needs to provide that to everybody. All right. So then it says in paragraph 8, in connection with the listing agreement, seller authorizes broker to do a bunch of stuff. He can put a for sale sign in the yard. You can market it on the internet. The seller has to leave all the utilities on. Okay. A lot of sellers will list the home. They will move on to their next home and think that it's okay to turn the utilities off. Well, what happens when an inspector comes and needs to inspect the plumbing, electricity, and anything that runs off of that? That's going to be a problem. Okay. Authorizes broker to obtain any information relating to any mortgages on the property. You can obtain a key to the property, have access to the property for purposes of showing. Okay. Paragraph 9, neither the buyer nor the seller may be held liable for the actions or words of the broker or licensees affiliated with the broker's firm. So the principles to the transaction, so a buyer and seller, this just says, hey, don't blame me if my agent says or does something dumb. Okay. Paragraph 10, all the information provided herewith or which may be provided to broker shall be true, and seller agrees to hold broker, sales associates, employees, and agents harmless from any cost, expense, or damage due to any information which is withheld by the seller from the broker or which is incorrect. Okay. So if the seller testifies that the kitchen countertops are granite, and that's what you put in the listing, and only to find out it's really Corian, well, that's not on the broker. All right, paragraph 11, broker shall use broker's best efforts to effect a sale of the property during the term of the agreement. Broker shall not be charged with the custody of the property, its management, maintenance, or repair. All right, so this is the stay in our lane clause. The seller cannot put on you that you have sole custody of the property. In other words, you're in charge of making sure the pipes don't burst or anything like that. Right? Or the management of the property, maintenance, or repair. That's not you. All right, now paragraph 12. If the property becomes vacant during the terms of the agreement, seller must notify seller's insurance company and request a vacancy clause to cover the property. Again, if anything in these OREC contracts is bolded or underlined, it's important. Broker is not responsible or liable in any manner for personal injury to any person or for loss or damage to any person's real or personal property resulting from acts of third parties, vandalism, theft, freezing water pipes, dangerous conditions on the property's non-compliance with any law or ordinance, any act of omission not caused by the broker's negligence. Seller agrees to protect, defend, indemnify, and hold broker harmless from any liability for which broker is not responsible under the agreement. All right. Paragraph 13 talks about forfeiture of earnest money. Forfeited earnest money, if any, shall be divided equally between seller and broker, except that broker's portion shall, in no event, exceed the agreed compensation, provided, however, that no release of buyer or waiver of a forfeiture of earnest money after a contract is executed shall relieve seller of any obligation to pay compensation. So if earnest money has been forfeited because maybe the buyer breached the contract and that earnest money goes to the seller, that's split, not to exceed what was originally agreed upon. And then it goes on to say the term broker herein shall include any sales associate whose signature appears on this agreement. So in other words, the broker doesn't necessarily have to sign the agreement where it says broker. Okay, and paragraph 15 speaks about fair housing. Paragraph 16, seller and broker agree to the terms herein set forth and understand that this is a binding agreement and it cannot be canceled or terminated except upon their mutual written consent. Okay, doesn't mean you can't get out of it. It just means it has to be in writing. Seller acknowledges that seller has read and received a copy of this agreement and that the copy of the Oklahoma Real Estate Commission contract guide has been made available to the seller in print or at this website. And it says if the broker is a member of the MLS, seller is giving authorization for the broker to enter this listing in the MLS and every other website that it connects to. Upon execution of a purchase contract by both seller and buyer, the broker, which means listing broker, shall have no duty thereafter to submit subsequent offers for the purchase of the property unless the contract specifically provides otherwise or this sale does not close. So if you're under contract and another buyer comes forward, this paragraph says that seller's agent is not obligated to present those offers. Is it wise to do so? Probably, but you're not obligated. All right, so paragraph 20, to facilitate the showing of said property, seller grants the broker permission to place on property a lockbox containing a key, and then it goes on to list what the risks of doing that are. And so as a result, the seller has the option to allow or not allow a lockbox to go on the property. Now, I would never recommend putting a combo box on there. It invites theft, but, you know, a super box, I think, is perfectly fine. Seller, this is a big one. Number 21, seller acknowledges that individuals viewing the property during the term of the agreement may take photographs and videos of the property or of items within and on the property. So this is a big deal. Unless the seller doesn't want that, and that's got to be disclosed in the agreement. And there's room for it. All right, here we go. Paragraph 25. Because that unnerves certain sellers, especially if you have a high-priced property. You don't want people taking videos and pictures of the contents of that home. All right. And then paragraph 22, the seller and broker agree that broker, in response to inquiries from buyers or co-op brokers, shall disclose, with the seller's approval, the existence of offers on the property. Okay, where disclosure is authorized, broker shall also disclose whether offers were obtained by the listing licensee, another licensee in the listing firm, or by a cooperating broker. All right, so are there offers on the property, be it verbal or written? Got to disclose it. So seller can decide they do or do not authorize the broker to disclose the existence of offers on the property. Paragraph 22, seller is aware that a residential service agreement, this is a home warranty, can be purchased for the seller's property that would be transferable to the buyer. The cost of that is approximately X amount and can be withheld from seller's funds at closing. It is the seller's decision to either purchase one or not purchase one at this time. And then paragraph 24, has the seller been notified by any city or county government agency, or is the seller aware that the property is in a flood zone? All right. And then paragraph 25 would be anything additional that you might want to include. No one sees this except you and the client. All right. And then you would execute this as appropriate, filling in all of the necessary information. I'll fill this out in its entirety as an example and place this on our White Rock internal website as a sample. And then, as with the buyer broker agreement, they include the disclosure of seller to seller of brokerage duties, and it just outlines what the seller's options are and what the brokerage duties actually are. Okay, so you initial and sign were appropriate, seller initials and signs were appropriate, and that's pretty much it. All right, so I thank you for your time. I hope you found the video helpful. And if you have any questions, please don't hesitate to reach out.